At a meeting of Americans United for Separation of Church and State, Dr. Hammond spoke about the intents and purposes of the Founding Fathers with respect to the Establishment Clause, the First Amendment of our Constitution, which begins, "Congress shall make no law respecting the establishment of religion." Dr. Hammond was introduced by Mr. Harry Schwartzbart, President of the San Fernando chapter of Americans United for Separation of Church and State.
We are honored to have as our speaker this evening Dr. Phillip Hammond, the D. McKenzie Professor of Religious Studies and Sociology at the University of California in Santa Barbara. He has a number of credentials to his credit, but the main thing as far as we are concerned is that his specialty is religion and politics. He was educated at Willamette University in Salem, Oregon, and Columbia University in New York. He's had a distinguished career as a teacher, author. He's written more than a dozen books, and he's received numerous honors and awards. His topic tonight is the religious face of our Founding Fathers. Dr. Hammond.
Everybody believes that the Supreme Court should render decisions only as they accord with the Founders' original intent. There are two views, however, of what original intent means. There is the view of what are called the strict constructionists. These are people who believe that it is possible for us in late 20th century to know every thought held by those who wrote the Constitution, the Bill of Rights. Also, they hold the view that the Supreme Court should make decisions only on matters that are mentioned in the Constitution. Former Attorney General Edwin Meese is a strict constructionist. Robert Bork failed to get approved by the Senate because he is a strict constructionist. On the court today, William Rehnquist, Anton Scalia, and Clarence Thomas are strict constructionists. The other view, and it's the view that I share, might be called the liberal interpreters, who feel that the Constitution must be fit to the times in which it is being consulted. Professor of Law Harvey Jones has this to say as a liberal interpreter about strict constructionists. I quote him, "To consider constitutional law as if it were a mere attempted reconstruction of the intention of the Founding Fathers is about as helpful as the old query, if I had had an uncle, would he have liked prunes?" I go on. Nowhere is this more true than in the law of church-state relations. It is the task of the Supreme Court to keep the historic purpose of the First Amendment a living influence in contemporary society. Law professor Lawrence Tribe, also a liberal interpreter, calls the strict constructionist view of original intent a mythical beast. He writes, "Even if such a beast could be captured and examined, how relevant would it be to us today? The constitutional text is not enough. We need to search for and explain our selection of the principles behind the words." I want tonight to explore those principles and that purpose, believing that that is what the religious beliefs of the Founders really means for us. And I want to do that by exploring a series of decisions, carefully selected, I grant you, to try and show a development process in which, I will argue, what is being protected by the religion clauses of the First Amendment is the sanctity of individual conscience. The first case I want to refer to is from 1878, the Reynolds v. United States, emerging out of the territory of Utah. Mr. Reynolds was a Mormon with 2 wives and lived in the Utah territory. The Congress had passed the laws regulating life in the territories, and so it was before the Supreme Court that the case was brought, and Mr. Reynolds was told that he could not be married to 2 wives at the same time. Soon after this, as you perhaps know, the Mormon Church dropped its stand regarding polygamy, and that led to the statehood for Utah. But in the course of writing this decision, Justice Waite used the following words. And this is what makes the Reynolds case important, not because it dealt with polygamy, but because of the words I'm about to read. Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. Note the distinction between belief and action. Belief is utterly free, fully protected by the Free Exercise Clause. Action is not fully protected in the same way. That distinction between belief and action held clear until 1940, and that is the next case we look at, known as Cantwell versus Connecticut. I've got to set the stage for you in this case. Mr. Cantwell was a Jehovah's Witness. He had 2 young sons with him. He walked into a heavily Catholic neighborhood in New Haven, Connecticut. He was carrying a little hand-wound phonograph, and he put a record on and played it, and among other things, the phonograph said, "The Catholic Church is the whore of Babylon," and the police arrested Cantwell for breach of peace. And, of course, New Haven had a law that said breach of peace. Now, before this case, the case would have been very clear. The police had a right because the breach of peace law had been written not targeting Jehovah's Witnesses, not targeting any religion. It was simply a law that everybody had to obey. But in this case, the justices said, no, hold on. There may be some behaviors which, because they are religiously motivated, are protected, even if those same behaviors, otherwise motivated, could lead to arrest. And Cantwell's case was overturned. However, 2 problems emerge out of Cantwell. The first is obvious, and you could guess what it is. If some religiously motivated behavior is protected by the Free Exercise Clause, where do we draw the line between those behaviors that are and those behaviors that are not? The answer came with the development of a doctrine that is now known as the state's compelling interest. In other words, it's very, very important to the state to try and prohibit some action that a person claims to be religiously motivated. In those cases, then, the inalienable right to free exercise of religion is trumped by the compelling interest of the state. This was developed in what was known as the Sherbert test, in a case involving a Seventh-day Adventist who was told by her employer that she had to start working on Saturdays. She quit her job, asked for unemployment compensation, and was turned down on the grounds that she had made the choice. And the Supreme Court upheld her in developing the notion of was she sincere in her religious belief? Was the change in her job actually a burden for her religious free exercise? And deciding that it was, out of this comes the compelling interest kind of notion.
Motivation becomes the question for the courts.
The first problem then was where to draw the line between protected religiously motivated behavior from unprotected religiously motivated behavior. The second is more complicated. The second problem is how to determine when an action is truly motivated religiously. And there are 2 cases worth noting here. The first from 1944, one of the more bizarre cases ever before the Supreme Court. It's called Ballard v. U.S. Guy Ballard, his wife and son, operated a religious group called the I Am religion, and among other things they claimed to be able to heal people for money. And they made that offer using the U.S. Postal Service and were convicted of fraud. The case ends up eventually before the U.S. Supreme Court, in which the court makes this very, very critical distinction that the government is in no position to determine the truth of the Ballards' religious beliefs, only the sincerity with which those truths, quote unquote, are held. Justice Douglas wrote that majority opinion in 1944, and he quoted the memorable words, "People may believe what they cannot prove." By 1965, the notion then of sincerity, the notion of integrity of conscience is made even clearer in one of the great cases, in my view, U.S. v. Seeger. Seeger was an agnostic, asked for conscientious objection, had been turned down by his draft board. The Supreme Court unanimously found that whatever it was that he called his conscience was, in his life, playing the same function that religion does in the lives of people who declare themselves to be religious. Once again, you see the emphasis is on sincerity. Conscience thus becomes what the free exercise protects. Now, it's not yet clear in law whether this principle is widely accepted and widely controlling, but in my opinion, it is clearly on the way to being that principle, and that is what I think the Founding Fathers would applaud. It is, if I may say it a different way, it is the fact of conviction, not the content of that conviction, that the First Amendment protects in the Free Exercise Clause. Government is so far so much more intrusive in people's lives today than ever before. Government regulates education, health care, marriage and death certification, inheritance laws, etc., etc. So there's all kinds of more rooms for stumbling to go on. You know many of these strategic cases. Prayer in the public schools was declared unconstitutional in 1962. Bible reading in a devotional manner was declared unconstitutional in 1963. We still cough and stumble over how much is allowed in the way of Christmas displays during the holiday season, and so on and so forth. There's a very mixed bag of decisions. It's very hard to know in a predictive way what the court's decision is going to be when one of these kinds of cases comes up. But it is quite clear that what the principles are that are at issue here. What is not quite, the principles are clear because what is at issue is a clearly definable religious action or a religious symbol or a religious behavior. Things get a little more complicated when the religiousness of what is at issue isn't quite so obvious. There is a case that illustrates this very nicely called Torcaso v. Maryland. Roy Torcaso wanted to be a notary public in the state of Maryland. He took the training for it, but when it came to get his license, he was told that the Maryland law would require him to declare a belief in God. He refused to do that on the grounds that he was an atheist. The Maryland Supreme Court found against Roy Torcaso. The Supreme Court of the U.S. overturned the Maryland court, saying that government may not force a person to profess a belief or disbelief in any religion. Or take the cases involving creationism in the public schools. In 1967, Arkansas passed a law which prohibited the teaching of evolutionary theory, obviously preferring that creationism be taught. Justice Fortas, in this case, wrote the unanimous opinion, noting, and I want to call your attention to the closeness of this wording, noting that Arkansas not only was violating the No Establishment Clause by endorsing what is undeniably a religious doctrine of Genesis creationism, but was also violating the Free Exercise Clause by enforcing what he called orthodoxy, indoctrination, and conformity. In other words, by enforcing a belief in an area where people have, or should have, free exercise of conscience. Things get even stickier when we move into areas that don't appear to be church-state issues at all, and indeed often don't come up under the First Amendment clauses, but come up under the 14th Amendment, the due process protection. And that's when government writes into law a standard that may have been derived from a religion, but makes that a standard for all persons. Now, don't misunderstand. Of course, government can do that. Government does do that. Laws against murder, laws against stealing can, if you want, say, are found in their origins in the Ten Commandments or some other code of that sort. But they are constitutional, not because that is their origin. They are constitutional because, and here are the key words, because government can state a secular purpose for writing those laws against murder, against stealing. Government's role is to protect life, to protect property, and so on. So we come now to a set of issues, none of them fully settled in law, not necessarily looking like church-state issues, but issues where I would insist Constitution and the dignity of the Constitution is at issue. I think I'm going to be stating a position. I hope you will agree with it. If you don't, you can tell me afterward, after I get in my car and drive out. I think I'm going to state a position which is the Founding Fathers' religious beliefs and original intent. I'm going to talk about three cases. The first can be called the granddaddy case of the category I'm talking about, and that is abortion. Though it is true that Rehnquist, Scalia, and Thomas would love to overturn Roe v. Wade, the 1973 decision, which was, as you perhaps know, based on what they claimed, what the majority claimed, was finding a right in the Constitution to the right to privacy, and thus guaranteeing the would-be mother's choice in the first trimester of her pregnancy to abort or not as she chooses. That seems to me at this point still to be secure. It is not the Roe v. Wade case I want to talk about then, but a case from 1989 arising in Missouri known as the Webster case. The Missouri legislature passed a bill stipulating that Missouri public money could not be used for several things. It could not encourage abortion, that public money could not. It could not pay the salaries of public employees or the costs of public facilities that would be used for abortion purposes, and it required a viability test to be performed on the fetus of any woman seeking an abortion if she is 20 or more weeks pregnant. But in addition to those three provisions, this legislative bill also wrote a preamble declaring that life begins at conception. It is astonishing to me that 5 justices, the majority, approved this legislation, but it is ennobling to realize that 4 did not, and Justice Stevens wrote the dissent. I want to quote from his dissent, and if these are not ringing words in your mind, then I'm sorry. I quote, "I am persuaded that the absence of any secular purpose for the legislative direction that life begins at conception makes the relevant portion of the preamble invalid under the Establishment Clause." I turn my attention next to the case of euthanasia or assisted suicide. I want to start with a 1990 case called Cruzan v. the Missouri Department of Health. I'm not picking on Missouri. It just happens that this is the way they fall. Nancy Cruzan was a young woman who was injured in an automobile accident and was unconscious, and for 6 years at the time of this case, for 6 years had lain in a vegetative state in a hospital connected to life support systems. Her parents had testified that Nancy many times before her accident had expressed her desire never to be put into life support situation, and her parents asked that she be taken off of the life support systems. The doctors testified that Nancy would have no chance of recovering and would die if taken off the support system. The Missouri Department of Health ruled nonetheless that their job was to keep her alive. The Supreme Court heard the case and again, by 5-4, upheld Missouri. Again, Stevens, again joined by Justices Brennan, Blackmun, and Marshall, wrote the dissent. You'll hear echoes now of the Webster case. I quote, "Missouri's regulation is an unreasonable intrusion upon traditionally private matters encompassed within the liberty protected by the Due Process Clause. Not much may be said with confidence about death unless it is said from faith, and that alone is reason enough to protect the freedom to conform choices about death to individual conscience. Missouri asserts that its policy is related to a state interest in the protection of life. In my view, however, it is an effort to define life rather than to protect it. That is the heart of Missouri's policy. Missouri insists, without regard to Nancy Cruzen's own interests, upon equaling her life with the biological persistence of her bodily functions. There is a serious question as to whether the mere persistence of their bodies is life, as that word is commonly understood, or as it is used in both the Constitution and the Declaration of Independence. It is not within the province of a secular government to circumscribe the liberties of the people by regulations designed for the purpose of establishing a sectarian definition of life. That was 1990. Stevens was in the minority. But just a few weeks ago, the 9th Federal District Court, covering the western states, handed down an 8-3 decision that is a stunningly accurate reflection of Justice Stevens' viewpoint. It involved 3 terminally ill but competent patients and their doctors in Washington State, who sued for the right of the patients to request assistance from their doctors for a sure and painless death. Now, these patients, or other patients I should say, already have the right to ask that life-maintaining machines be removed if they are terminally ill and if they are judged to be competent. These people were competent, but they were not hooked up to life-sustaining machines. A majority, 8-3, agreed with these plaintiffs. And like Justice Stevens, the majority in this Ninth Circuit case realized that more is at stake than simply life versus death. The case involves choice, dignity, and self-direction. It looks not at whether life is sacred, but how the sanctity of life is to be understood. Listen to the final paragraph of the district court's decision. There is one final point we must emphasize. Some argue strongly that decisions regarding matters affecting life or death should not be made by the courts. Essentially, we agree with that proposition. In this case, by permitting the individual to exercise the right to choose, we are following the constitutional mandate to take such decisions out of the hands of government, both state and federal, and to put them where they rightly belong, in the hands of the people. We are allowing individuals to make the decisions that so profoundly affect their very existence, and precluding the state from intruding excessively into that critical realm. Those who believe strongly that death must come without physician assistance are free to follow that creed, be they doctors or patients. They are not free, however, to force their views, their religious convictions, or their philosophies on all the other members of a democratic society, and to compel those whose values differ from theirs to die painful, protracted, and agonizing deaths. My final illustration of how church-state issues get involved in erstwhile secular disputes has to do with homosexuality. Law is much less developed here. There's been very little, although things are percolating now, as you well know, with the case in Hawaii of same-sex marriages, some efforts in Congress to write legislation that would allow individual states to deny recognition of same-sex marriages should that become possible in Hawaii and so on. In other words, this issue that I'm talking about is clearly ripening as a legal issue. My point here is that it is another instance where the question comes down to human dignity, to liberty, to equality of all citizens, equal recognition of conscience. Now, some may believe that homosexuality is evil. No doubt the Georgia law prohibiting sodomy in that state and other laws like it in other states are premised on the view that it is evil. But the fact that some people believe that it is evil has no secular purpose. It is a view not universally shared, and that imposes one religious or moral position on all. This, in my reading, is best expressed in a recent book called Virtually Normal by Andrew Sullivan, who until recent months was editor of the New Republic. In that splendid little book, he says the following: The vast majority of people engaging in homosexual acts regard those acts as an extension of their deepest emotional and sexual desires, desires which they do not believe they have chosen and which they cannot believe are always and everywhere wrong. When the subject of homosexuality emerges, it is always subject to emotive passion and affects matters of religious conscience. The act of openly conceding one's homosexuality is in some ways an act of faith in the sturdiness of one's own identity and the sincerity of one's own heart. Marriage is not simply a private contract, it is a social and public recognition of a private commitment. As such, it is the highest public recognition of personal integrity. Near the end of his book, Sullivan says that homosexuality is not the equivalent of a religious calling, his words, but who can doubt that to him certainly, but obviously to many others as well, it involves the very core of one's being. I return then to the original theme, the religious beliefs of the Founding Fathers. Did they foresee the religious implications of abortion, euthanasia, and homosexuality? Of course not. Neither did they anticipate jet travel, public schools, or artificial fat. But did they conceive of America as a place where conscience should be king, where freedom of religion should prevail unless some compelling reason, some secular purpose exists for limiting that freedom? And did they conceive of religion then as fundamentally the language of conscience? Of course they did.
Realization of this project was made possible by a generous grant from the James Hervey Johnson Charitable Educational Trust.